Good day, everyone. Eric from Helps here today on September 25th, 2025. Glad to have you here. Glad to have you participate today. My name's Eric, attorney for Helps, and what we do is we educate seniors about how they can maintain their financial independence, and instruct them why they don't need to pay debt and how their income is protected. So, the title for the topic today, and I'll talk about this in a second, is Bankruptcy for Seniors or Helps. Before I get into that, I'll just read a comment someone made to one of our videos, or it could have been a senior living video. And they said, I am crying watching this as I worked 51 years and I retired 4 years ago. I was hit by a drunk driver. I've had 12 surgeries in the last 4.5 years and need two more on my back to prevent paralysis. I had to live off of credit cards until I got my financial disability in order. I can only eat once a day paying them. I can't believe I'm hearing this news. So if this is your first time listening to Helps, to this YouTube channel, please listen to us. We're going to educate you about your financial rights and why you don't need to worry. Our most important message to seniors is that federal and state laws protect your Social Security, your pension, your disability, your VA benefits, IRA, 401k. Virtually any form of retirement is protected. It can't be taken from you. It's available for your needs. It's available for your needs, and you don't need to pay old debt that you can't afford to pay. Now, when I say old debt, I mean any debt at all, even if it was incurred yesterday. Um, and also, there is a way to stop debt collectors from harassing you. In 1978, Congress passed a law called the Fair Debt Collection Practices Act, which law provides, among other things, if you're represented by an attorney, debt collectors can no longer call or send you demand letters anymore. They have to leave you alone. And that's what Helps does. What we do when people find out about Helps, they call us, we interview them, we talk to them about their situation. They decide they want our help. We can click a button and they can be enrolled immediately. We don't turn anything away that qualifies for our service. Um, and then you're going to give us the collectors or creditors you owe money to. We're going to send a cease and desist letter. And if it's a debt collector under the law, they can no longer call you or send you demand letters anymore. They have to deal with us, not you. So peace returns to your life. And then we're always there. We're there ongoing, so you don't have to deal with collectors again. And if you get a new debt collection notice from a different debt collector or an old debt collector that we sent a letter to assigns it to a new debt collector, all you need to get us that new information for that new debt collector. We're going to get them a cease and desist letter, and they're going to leave you alone. So this is good news for seniors. And then I'll answer questions that are in the chat feature. Before I talk about bankruptcy versus helps, I'll see if I got any questions I can deal with here. Um, Michael says, while waiting to start, I served with suit from Jefferson Capital. And there was a telephonic hearing, waited but no call. Clerk said they had the 29th to file an outcome. If they file, should I file a motion to dismiss or not? You don't need to do anything. So, Michael, if your income, Social Security, or pension is protected, you've been sued. You don't need to. If you don't need to contest the lawsuit, you can if you want, especially if you don't owe the money. But you don't. But if you owe the money, a lot of times that's just a waste. You don't need to do anything. Okay. And you can always call and talk to us. Okay. So I'm going to talk a little bit about bankruptcy. Is bankruptcy for seniors, does it make sense or helps? I'm pretty qualified to do this since I probably filed between 30 and 40,000 bankruptcies before I started Helps. So I know a lot about bankruptcy. In fact, Helps was started specifically because seniors didn't need to file bankruptcy. Very few did. So a guy called yesterday from Florida. He was a client from Helps, and he was a little worried because he'd gotten a writ of garnishment on his employer. He worked for a security company, And I'll just read you what I sent this to our paralegals to help him understand this. He was being garnished for a job he had uh, as a security guard. And it was a credit union that garnished him. He had a judgment against him for a little bit over $10,000. I explained how in Florida the the federal exemption is in play, which is $217.50 net per week in wages is protected. Okay, some states protect more, but every state protects a minimum of $217.50 net per week. He was paid every week, and sometimes he earned up to $300 net after taxes were taken out. Now, if he made $300 and they can garnish 25% of his income, 25% of $300 would be $75, which is a little bit over $217.50. So he would bring that amount home, like $225. The rest would be subject to garnishment, with an exception, which I'll talk about in a second. Um, I said he was being garnished by a judgment by a local credit union. Somehow they found out where he was working. And I said to our paralegals, it's relatively uncommon for one of our clients to be garnished. The stars have to align. Typically, creditors don't investigate. However, the judgment creditor here was a local credit union, and he had probably disclosed this job to them in the past. So they knew where he worked, and they got their judgment and decided to garnish his wages. Now, out of 4 paychecks, maybe 2 of them would be less than $217.50, and then 2 of them would be over that. Okay, so he stood the risk of being garnished a little bit of money each time. Now, I want to make it clear. In some states, garnishment even isn't permitted. South Carolina, Texas, and then a lot of states protect from garnishment a lot more money than $217.50 net per week. Um, New York, California, I mean, a lot of states do. Um, but I explained, Florida also protects if you have a dependent. Uh, they can protect an extra $750 a week in wage exemption. It's protect for wage earners with dependents. I'm not sure if it's 750 on top of 217.50. I think it's just flat 750. Okay. Um, Now this was important for him because he supported his wife, and his wife made minimal Social Security, and more than half of their income supporting his wife. Uh, More than half the income for the family was his income, and so she was his dependent under this rule. Now, for filing a tax return, if they filed jointly, she wouldn't be a dependent, but for implementing the protection of 750 in wages in Florida, she would be his dependent. Okay. Um, so he was going to file. There's a form to file to claim as an exemption for that 750, and he'll present that evidence to the court. Along with filing that, he's going to give him a copy of his income and his wife's income, and he'll be able to present that at probably a Zoom hearing or something over the telephone to the judge. And the judge should order that the garnishment not take place because he never makes more than $750 a week. Um, but um, but I told him he had. Let's say he was being garnished, or he was in a state where he could be garnished. I told him he had a couple options. He could ask his employer to lower the hours he worked so he netted less than $217.50. Often he did that anyway. He didn't really want to do that. I told him you could lower your job there and take another job as long as each job you're making less than $217.50. They couldn't garnish anything. And then I explained to him you could file bankruptcy. He didn't have any assets over the state exemption. I sent him a link to a website for a company called Upsolve that can file bankruptcy for people for free. And it's a 501c charity. They don't file bankruptcy if you're buying a home, and you have to do it yourself. It's kind of complicated. A lot of seniors don't really need to file bankruptcy, but if this case, if they could get at his wages, he could consider filing bankruptcy. Now, it's still going to cost him some money for the filing fee, and he's got to take a couple of classes, but I sent the information on that he could look into that. And then he was told me when he first called, he was really worried because he was garnished that he was going to lose his job. I explained that there's a law called the Consumer Credit Protection Act that prohibits an employer from firing you if you have a writ of garnishment. The only exception is if you had multiple writs of garnishment, they could legally do it. Although in 46 years of practice, I think I only recall one time whenever I had a sense that a client was let go of their job because of a problem from a creditor garnishing them. But even in that instance, I think the reason was otherwise. Employers are used to that having happened. But in this guy's case, he's really not going to lose anything. He doesn't really need to file bankruptcy. But we're happy to explain to our clients or people that call us their rights and how bankruptcy works. We have emails that explain that. But for a lot of seniors, bankruptcy just is not necessary and they can't afford it. It's not the answer. And then sometimes bankruptcy can get you in trouble. Maybe you have an asset that's over the exemption, file bankruptcy, a trustee could seize that asset, sell it, use it to pay your debt. Whereas if you don't file bankruptcy, a creditor wouldn't do that. But a bankruptcy trustee, they have more power than a creditor. They could do that. So, there's a lot of reasons why seniors really don't need to file bankruptcy. There are occasionally exceptions, but not very often. Okay. See if there's questions here. Mrs. H asks, I'm considering garnishment on a paycheck. Do they take all that part of the wages or do they take a portion of the check? How does it work out? No, they just take a portion. Okay. It depends on state law how much is protected. If the state doesn't have a law, then the federal law goes into effect. And so if the federal law protects a minimum $217.50 net, that's $435 every 2 weeks, about $950 a month. So if you got paid every 2 weeks and you got a check for $400 net, that's less than $435. Your employer is going to file an answer to the garnishment and say, there's nothing there to be taken from you. They're not going to take anything. Now, if you got $500, they could take maybe $65. Okay. But then if you live in a state like California, the exemption for the wages could be like $700 a week or even more. Or Texas, where they don't even permit garnishment, South Carolina. It depends on the state. Bottom line is we just don't run into our clients facing problems with garnishments. It's just very rare. But if ever were, we know how to answer your questions and give you the information you need to know. Hi there, I have a question. If you have an SBA loan and credit card debt, does it qualify for not Social Security garnishment? No and yes. So if you owe the SBA money, that's the Small Business Administration, or another federal agency, FHA, Rural Development Commission. In 1996, they passed a law that allowed federal agencies, I'm not talking about student loans or I'm not talking about the IRS, to contact the Social Security and offset 15% of someone's Social Security you owed them money. They had to protect a minimum of $750, but if you made more than that, then they could take 15%. So yeah, if you owe the SBA money, it is possible that they could garnish 15% of your Social Security. Once again, we don't see that happening very often, but it is possible. Is there a way to get it stopped? Hit and miss. Normally, no. There was not a provision alone in the law to allow that to be stopped, but it seems like some agencies on their own have tried to work out something for people to be able to pay a little bit towards the debt. You could theoretically then file a bankruptcy and wipe out, for example, the SBA loan. I remember when this first came up, HELPS was pretty early on And a lady called and she was being garnished 15% of her Social Security. And she said, Eric, this debt I owe the SBA is 40 years old. There's no statute of limitations. And she never paid it for 40 years. And then all of a sudden she got to be 67 or 68, retired, starting getting Social Security, and she got a notice they were going to garnish 15% of her Social Security. What's the answer? Well, she could file bankruptcy and wipe out the SBA debt, and then since she's going to get the full Social Security. So if you ever ran into that kind of problem, you talk to us. We'll tell you what you can do. Okay? We don't file bankruptcy for people. We don't represent people in court, but we do educate people about what your rights are. Now, they're not going to take money out of your checking account. Remember, if you get Social Security or federal benefits, Mary, twice the amount you get each month is automatically protected in the bank account to which it's deposited, regardless of what funds are in there or where they came from. So if you got 1,000 in Social Security, 2,000 is protected automatically. You got 2,000 Social Security, 4,000 is protected automatically. Even if money in there came from another source. Okay. Now, if you owed the SBA money, or can they take it out of your bank account? No. The most they would ever do is say, send a notice, say, intend to offset 15% of Social Security. But once again, that isn't happening. If it were to happen, you call us, we tell you what you can do. There's virtually almost always an answer that's going to solve these problems. And this last guy I talked to, I wrote down this. I said, anyway, in the end, he was all calmed down and relieved and so thankful for helps. That's what he told me at the end. I talked to him this morning, in fact, earlier today. He called us. He was kind of frantic, out of breath. And I needed to check the computer. He was really upset. I explained everything to him, why he was going to be okay. Even if there's a problem, we know what to do. He didn't need to worry about home. And then at the end, he said, oh, I'm relieved. I'm okay. And he says, yes, you are okay. Okay. So Miss H asks, when taking out a personal loan and it's not used for bills but to do work on property, and after a while can't pay that back, will the bank put a lien on the property or sue for that loan? Well, they can always sue. They're not going to be able to collect from you. Are they going to sue? Maybe, maybe not. Is it going to be a lien on the property? It depends on what type of loan it is. They could have what's called a UCC lien, which means it's not a mortgage, but it's a lien that shows up on a title report. If you went to sell the property, you might have to pay it. Then, if you don't pay the debt after like 6 years, the UCC lien expires. You won't have to pay it. So we talk to people about and tell them what the law is on something like that. Okay. But if it was a real problem, maybe nothing would need to be worried about. Nothing needed to be done. So thanks for participating today. If you have any questions, put them in the chat feature. I'll try to answer them. This person contacted us from Virginia. She says, I'm a two-time widow and I'm 82 years old and recently moved to Virginia so that I can be with my son in my last days. I have some credit card debt from that move and from before. I would like to talk to someone about my just over $25,000 in credit card debt. I've been thank you. Okay. So yeah, we're going to call her back. We're going to explain to her how her Social Security is protected, pension, any other retirement income. She doesn't need to pay that credit card debt anymore. And if she wants to enroll in helps, we're going to enroll her in helps. She's going to give us the collector she owes money to, the credit card companies. We're going to send them what's called a cease and desist letter, and they're going to leave her alone. She's going to be fine. Doesn't need to worry. And so if you're in that position where you have debt you can't afford to pay and you're struggling, you don't know what to do, give us a call. Even if you've made arrangements to pay the debt, you can stop paying it. They can't, even if they sued you and got a judgment, they can't collect from you. You can stop paying it. Okay. One thing I tell people is that, a debt collector will never tell you what your rights are. They only have to tell you we're a debt collector and any information we obtain can be used for that purpose. They're not going to tell you what I'm telling you. They're not going to tell you that your bank account is safe. They're going to tell you that they can't go after your assets. They're not going to tell you that they can't touch your Social Security or pension. Instead, they're just going to try to get you to pay the bill, scare and intimidate you. So that's why I want you to listen to this channel, and we're going to give you correct information so you understand why you don't need to worry. CK asked, I'm from Michigan and been with Helps for over a year. Capital One sued me in August, and most recently Synchrony Bank. Is there a typical time frame where creditors attempt garnishment after judgment? Well, they can do it the next day, and a lot of times they don't. Now, the only problem in Michigan is, Michigan has this little different law that's unusual. Uh, they give you a rebate on property taxes if you have income under a certain amount, up to about $1,200, $1,300. Even if you rent, they can give you a rebate for property taxes. And you might say, well, Eric, I don't pay property taxes. Well, the law impugns that you pay property taxes through the rent you pay. And because of that, if you're in Michigan and you get sued, I think a lot of people get sued a lot more in Michigan because of this law. Because if you get sued and then you file to get this tax refund from the state can garnish the Michigan Department of Revenue and get that refund. Um, I think it's kind of the law could have been written to have protected that money because it's designed to help people that are poor. They could have protected that money to give to the people that are poor that needed it. Instead, they allowed a means for a debt collector who had a judgment to take it from you. So they give the money with one hand, and yet they take it away. They allow someone to take it away with the other hand. Now, how to stop that? You can file bankruptcy, wipe out the debt, and then you're going to get the refund into the future. We got emails that explain that. I've explained before how one times I've contacted at least once or twice the Detroit Free Press for them to publish an expose on this law. I thought it'd be newsworthy. That never got back to me. And one time I wrote a letter to all the legislators in New Orleans. Or in Michigan, saying, hey, maybe you guys should look at this law again. Never heard back from anyone. Why? Well, I suspect no one read it, or maybe they're politicians. They get paid by lobbyists for the credit card companies and the banks, and they don't want to change the law. Gus asks, it seems like LVNV funding is the most aggressive credit collector. Well, they're one of the top, but the most aggressive collector is the one that's coming after you, Gus. What I tell people is it doesn't matter if you're on Social Security or pension, disability, VA benefit, protected income. I don't care if you've got 100 of them coming after you that can't do anything to you. Okay, you don't need to worry about it. Okay. Richard asked, can a suit move forward without ever being served? It's been over 2 months since suit was filed. No, they got to serve you for it to start. Okay. Um, and sometimes in certain states, they have so many days to serve you. And if they don't serve you within that time period, then the court will dismiss the case. They'll dismiss it. They call it without prejudice, meaning that the creditor could file it again. So, but once again, you don't need to worry about whether you're sued or not. Whether you're sued or not, they can't do anything to you. So CK said, I have a lot of equity in my home. Chapter 7 is an option. That's right. It depends on your state, obviously, but you're right. So let's say, for example, uh, you had a home that was worth 200,000, you owed 50,000 on it, and then the homestead exemption where you live is 50,000. So that means if someone got a judgment against you, um, if you file bankruptcy, a trustee would have to pay off the 50,000 you owe on the home, give you 50,000 of your homestead exemption. There'd be $200,000 for him to pay your creditors. So if you file a Chapter 7, the trustee could put your house up for sale, sell it, pay 50,000 on the loan, 50,000 your homestead exemption, use the rest of the money to pay your creditors, and anything left over goes back to you. But you say to yourself, I don't want that to happen. I don't want them to take my home. Well, you don't need to file bankruptcy, because even if someone got you a judgment, it isn't a practice of a judgment creditor to try to take your home, even if you have equity in it over and above that homestead exemption in the state where you live. They simply don't do it for a lot of different reasons. Okay. And I know I've been doing this a long time. They don't do it. And so that's why I say sometimes, I'll see a problem where a senior gets in problem by filing a bankruptcy. Most bankruptcy attorneys are going to be able to tell people that and warn them of that. They might steer them to what's called a Chapter 13. Say, well, you can't file regular bankruptcy, but you can file Chapter 13. Let's say the guy owed 20,000 in debt. So under Chapter 13, as long as you pay that 20,000 back over a period of 3 to 5 years, um, you keep the home. But the problem paying 20,000 over 3 to 5 years, you might have a payment of $400 and $450 a month. You simply can't afford it. So sometimes a bankruptcy attorney might steer a client into filing a Chapter 13 when really the person can't afford the Chapter 13 bankruptcy payment. And they didn't need to file it in the first place because the creditor wouldn't do anything to them. If they got a judgment, they were going to take his home. He didn't need to worry about it. But then the bankruptcy attorney puts them in a Chapter 13. And then the way they design the fees commonly is that they get paid up front. They get paid first. So you're in the Chapter 13 for 6 months. Attorney's been paid or a year, and then finally you realize you can't do it anymore. You stop making the payment. Something happens. Case gets dismissed. Attorney doesn't care. He's been paid his fee. So sometimes filing a bankruptcy is like getting to a briar patch. You get in there and you have all these stickers you can't get out. It can be a real mess. So this person contacts us from Ohio. It says, my wife and I are both on Social Security only. We owe the hospital and doctor bills. We also have our property taxes for this year. We have lower income. We need to get ourselves out of this mess. We are considering moving out of our house into a rental. We need to know what we can and can't do. Our monthly bills equal our income alone. That doesn't count money for food or prescription. I have major heart issues. My wife is insulin dependent, diabetic. So, we'll call this person or they'll call us back. We'll call them and talk to them. If they owe credit card debt, they could stop paying that. There may be a provision in their state to have the property taxes lowered or put off till when you sell the house. Some states have provisions for seniors with lower income to postpone payment of the property taxes. Maybe they don't have any equity in the home. Maybe they owe 150 on a home and it's only worth 175. So the time they sell the home, they might get $10,000. Well, one option they have is just stop making the house payment, let the home go into foreclosure. They might live in the home for a year and a half before it goes back without having to make a rental payment, without making a payment. So there's a lot of options. We go over that with people. Remember, our main mission is to protect you from debt collector harassment. But our second mission is to educate you how you can maintain your financial independence. So, we're going to give you things that you can do or you can think about that will help you to remain financially independent. I'm not sure what your question is, Michael. Okay, this person contacts us from Arizona. I'm currently with Freedom Debt Relief. That's a debt management company. If you're with a debt management company or debt settlement company, the question I have for you, when you enrolled with them, did they tell you that your income was protected, that no one could touch your Social Security or your pension or your disability? And if they didn't tell you that, you weren't given complete, honest information. You weren't given complete, honest information. Okay. Um, and he goes on to say, with Freedom Debt Relief, I just found out about your company. I gotta shut my phone off here. Um, I've gotten sued twice so far, and I'm pretty sure a third one's coming. I've been making monthly payments to try to pay my credit cards, but it's getting difficult. Do I have to stay with this company, or can I come with you? I am Social Security. I'm scared to death. I don't know if I read this one yesterday. It looks familiar, but you don't have to stay with a debt management company if you're signed up with them. You can cancel with them anytime you want. You don't need to pay them. If you cancel, ask them, why didn't you tell me when I enrolled with you that my income was protected? I didn't need to be enrolled with you guys. I see what they say. Person asks, how long can the debt collector keep trying to collect if they know I can't collect Social Security? Well, if we send out a cease and desist letter to a debt collector or creditor or whoever, you know, our help is ongoing, literally forever. The reason is because it's not uncommon for a debt collector or creditor to sell the collection to a different entity to try to collect from you, and you may get a debt collection notice, 6 months, a year, 2.5 years, a year, 2 years, 3 years down the road. You may get sued down the road. So, I mean, they can still try to collect, but they're not going to be able to collect anything from you. So you don't need to worry about it. That's why helps is here ongoing, so that if you ever have a problem in the future, you can always call us and we'll go over it. This person comments, they say, I like your videos, but I think you're missing an important point. If they sue you and get a judgment against you and you own your own home or property, then they can get that after you die or get what you owe them after you die. Not necessarily, okay, for a number of reasons. Let's say you own the home with your spouse and the debt is just in your name and you die before your spouse and the property automatically goes to your spouse and death disappears. Let's say you had a home and one of your kids was on there as a joint owner with survivorship rights. So you pass away, boom, property goes to the kid. Uh, when you die, the judgment lien goes away. Or if you live in a state with a higher homestead exemption, or you can get the homestead exemption, you go to sell the home, you can get the lien removed. Um, there's a lot of reasons why a judgment lien may not really be a problem. Okay? Person asks, I'm 61. What is considered legally a senior? So our name is HELPS. It stands for Help Eliminate Legal Problems for Seniors and Disabled Persons. It doesn't matter how old you are. It just matters the source of your income. So if you get income from a disability, a pension, any form, Social Security disability, you can be under 60, 62 to get that. You can get Social Security as early as 62, regular Social Security. But if you're disabled, you get Social Security disability younger than that. We've got clients in their 30s here. So once again, it doesn't matter. Well, here's one. I wrote this one down. There's a comment on a video, maybe not one of ours, someone else, but he says, negotiate your debt. Pay $2 to $10 a month, no matter the amount of the debt. They legally must accept it. So I think what he's trying to say, if you pay $2 or $10, that they have to accept it and they can't sue you. Not the case. They can still sue. Doesn't matter. That's an old misnomer or old tale that really isn't true. Sorry, the telephone pretrial call was from the court paper. Just wondering who orders them. Okay, different states have different procedures, Michael. Uh, when you get sued, sometimes the court on the lawsuit, they'll have a court date, time, and stuff. But if you read it carefully, that's only if you're going to contest the lawsuit. If you're not going to fight the lawsuit, then it says they're just going to get a default judgment. So that's if you're going to contest the lawsuit. That's where that would apply. Okay? And no, you don't need to worry about it. If you're not going to contest the lawsuit, you don't need to worry about it. Does a lien on your home impact your homeowner's insurance? Should it? No. I don't know how the insurance company would even know that someone had a judgment against you. Wouldn't matter if they did. Okay. No, I don't see that as being an issue. I was paying my Bank of America card, they still sued me. That's a perfect example. You can make them payments, but if they decide they don't want it, they can still file a lawsuit. But you don't need to worry. So you can't prevent a lawsuit by paying them just a little bit of money each month. That's my point. But once again, it doesn't matter if they sue you or not, your income's protected. Joyce asks a good question here. If you pass the time for the statute of limitation, is the debt then gone? Well, not really. It may be gone. They may not be able to sue you to get the debt, but you technically still owe the debt, and it's legal for them to call. I've had people that have received calls for debts that are almost 20 years old. They can't threaten to sue you, and legally they cannot sue you, but they could still call to tell you, you're going to pay this debt. Usually, though, once the statute of limitation runs, you're not going to hear anything more. Second here. Okay. My only income is Social Security. The guy asked. I'm 76. Can creditors garnish my Social Security? Thanks for reading. Well, let's all answer together. The answer is no. Creditors can't garnish your Social Security. What about when it goes into your bank account? Well, remember, twice the amount of Social Security you get deposited in your bank account is automatically protected from garnishment by your bank, regardless of what other monies are in there where they came from. So no, they can't garnish it in your bank account. Just keep the balance less than twice the amount of your Social Security. So Richard asked, okay, if a collector can't serve the summons, but in the meantime receives a cease and desist letter from HELPS, can the court construe that as being served since it shows I am aware of the suit? No, no, not legally. I've had a number of people that contacted me that have been sued and they never recall being served. Okay. Um, and what do I tell them? Well, when I was filing bankruptcy, it didn't really matter whether they were going to wipe the debt out or not. But let's say you're a helps client and someone happens to, all of a sudden you get a judgment and you realize, well, I never got served. Sometimes I used to tell people, well, you can go to the courthouse and in the court filing, there's going to be not an affidavit, there's going to be a statement by how you were served. The person who served you is going to say he served you by doing this, that, or the other thing. It's like in some states, if you serve someone that lives where you live over the age of 14, that counts as service. Some states they can allow, in certain circumstances, service by mail. So, I mean, you could fight it and try to get the service overturned or quashed, say that it's not valid, but that's complicated. If you owe the debt, then they could just serve you again. Who would you represent you to do that? No one. You couldn't hire an attorney to do that. So sometimes if you get served wrongly and you owe the debt, they can't do anything to you. Maybe the best option is just to forget about it, not do anything. You may not have the ability to do anything. And it won't matter because they can't do anything to you. Okay? Makes sense? I think it makes sense. I mean, you can't right every wrong, but sometimes the wrongs that happen, there's no consequence for them. So why stir up the pot and make things when you don't need to? Okay? So Farmhouse says, since I joined helps this past summer, I haven't heard from any of my creditors. Well, that's what we like. Now, that doesn't mean that you might not in the future, Farmhouse. You might get sued sometime 2 years down the road, 3 years down the road. Who knows? And you don't need to worry about it. You're going to get a copy of the lawsuit to us. We're going to send a letter to the attorney who sued you, let them know that your income's protected. We're going to call you on the phone, explain why you don't need to worry. No, we represent our clients ongoing so they don't have to deal with this stress anymore. Okay? So if that's you and you're stressed by your debt, call us. The number, where is it? Down here? Yeah. 855-435-7787. We got people right now that'll talk to you. So here's one. This person writes in, they say, can you address how not paying a credit card monthly payment affects your credit score? I would think it would be completely trash your score. That doesn't seem like it would matter if won't you won't be buying a home, applying for loans, or trying to get another card. However, many landlords now require a minimum credit score and run credit checks before renting to you. If you could address this in future video, it would be appreciated. And I answered him this way. I'll read what I answered it. Your credit is based on recent credit history. It is possible to rebuild credit to a 700 plus credit score within 2 years and less. Helps will also give any senior. We have a program called 7 Steps to a 720 credit score. If you've been a client of Helps for at least 90 days, you can enroll in that program and start to rebuild your credit. It's free to our clients. Helps will also give any senior, whether you're a client or not, what is called a landlord letter, which explains to a prospective landlord the fact that the senior's income is protected and can't be taken. It will always be available to pay rent. This can be provided to a prospective landlord before an application fee is paid. Many landlords don't understand the fact that seniors' income can't be garnished. So you can take this landlord letter, show it to the prospective landlord you're making the application with, and they can say, well, they might say, oh, I didn't know that. Well, yeah, we can rent to you. I understand now they can't take anything from you. You're going to be able to pay your rent. Or they might say, well, we have corporate procedures and, it's out of my control. And then you could save the $40 or $50 application fee. We have emails that talk about that, gives a little bit more detail. Person writes in, they say, how about, there's another question on one of our videos. How about not paying back college loans, federal and personal? I'm 73 years old. I just stopped working. I still have college loans. Can that affect my Social Security? And this is my answer. In the past, 15% of Social Security could be offset to pay a past due federal student loan. Not a private student loan, but a federal student loan. At the present time, that is not being done and hasn't since before 2018. And if it begins, lower income seniors should be able to get an income-based repayment plan and often pay $0 towards their past due student loans. Yeah, we talked about this, how in May, the government was going to start, the education department was going to start trying to collect on past due student loans from seniors that are getting Social Security by offsetting 15% of Social Security. And then a month later, they came out with an announcement, no, we're not going to do that. We're going to worry about that later. Some talked about how it happened this fall. And then I've talked about how, in my opinion, it may not happen at all, at least not for a while. We'll have to wait and see. I might be wrong. Why wouldn't it happen? I've got the sense, I'm not going to get political here, but I've got the sense that Trump has this thing about Social Security and that people get Social Security should be able to get their full Social Security and it shouldn't be taken from them. So I got a feeling that the government isn't going to do anything to try to take money from your Social Security. Might be wrong. So Rockabilly says, hi Eric, help me over here. I've got a car I'm $12,000 upside down on. Should I call them to come and get it or just let them do it on their own? Let them do it on their own. Well, if you're not going to drive the car, you can park it. You could take the insurance off it. They'll get notice. They'll probably pick it up sooner. If you call them when you're current on the car payment, then you're never going to get through to the right person. But if you're behind and they call you about a missed payment, then you tell them you don't want it anymore, come pick it up. They might pick it up faster that way. Now, if you're going to drive it, you want to at least keep it insured. But if you're not going to drive it, you could park it, take the insurance off. Okay? Person contacts us. I'm 74. Got divorced a couple years ago. I've lived beyond my means since then. Racked up about $30,000 in credit card debt. My Social Security from my survivor's benefit from a previous marriage is, anyway, gets $1,750 in Social Security. My rent is about $1,900, so I'm way over budget. Will soon not be able to live here. I will owe taxes on income for this year. Maybe. I've taken a large amount from my China retirement account. I got this from my divorce. Actually, I had no retirement myself. I still have about 100,000 left, but just take out money when I need it. I'm terrified, lonely, and can't seem to quite get a plan together. I'm thinking of going back to work, but I don't feel well. I haven't worked in 10 years. I'm a bit stuck. So what did I say to him? I told him, call helps and we'll go over your situation. It's a little complicated to do a form like this, but he gets Social Security of 1750. He doesn't need to pay the credit card debt, 30,000. He can stop doing that. Um, obviously he's going to need to rent a new place. We'll talk about that. He's got $100,000 uh, from his retirement account, so he's got enough money to rent someplace. It'll work out. You'll be fine. He'll be fine. And that's what I say to almost everyone that contacts us. You know, we've got videos. I forget what the name of that video is. It talks about, if you're really totally destitute, this is a wonderful country to be destitute. There's a lot of help available. There's subsidized housing. There's food help. A lot of places have utility help. So, call us if you have a question. You don't have to pay your own debt. You can be stopped from creditors harassing you. If you have a question, you're worried or scared, you pick up the phone and you call, and we'll go over it. Okay? Person contacts us and they say, um, can a judgment become a lien on a? No, here it is. I'm a senior on Social Security. I'm 70 years old. I own a mobile home on a rented space. If I am sued, can they put a lien on the trailer? I'm in Idaho and the home is homesteaded. The exemption is higher than my equity. Well, you never lose the trailer. And then whether or not a judgment could be a lien on the trailer that would impact your ability to sell the trailer, it depends on the state. I've never seen it be a problem ever. Um, but um, they're not going to be able to take the trailer. That's the bottom line. So the question is, can a judgment become a lien on a mobile home that's on rented property? With very few exceptions under state law, the answer is no. Usually a judgment is a lien on a home on land. So if you have a mobile home that's on land that you own and the home has been detiled, in other words, the mobile home has been attached to the land on the legal documents, then yeah, the mobile home and the land, there could be a lien on it. But if the home hasn't been detiled and it's separate from the land, then no, a judgment could only be a lien on the land, not on the mobile home on the land. Bottom line is you're not going to lose it. You can call them and talk to you about it, but Don't need to worry about it. So this person contacts us from Tennessee. This says they're 77 years old. I get Social Security and a VA pension. My problem is that my monthly debt payments are as much as my income. I don't have any money left over for food, medication, and utilities. I don't think I will be able to keep making all my monthly credit card payments and personal loan payments. Can you help me? Yes, we can definitely help you. So we sent him an email about what we do. And we call him. He says he's worried about it, home equity. What happens if they, if there's a judgment? And we sent him an email why he didn't need to worry about that. So that was back in 2020. What's today? September 25th. Today he calls us, and one of our paralegals says he was transferred as a cold call. In other words, the first time call. But he called us several years ago, so I found him and updated his contact information. He was served by LVNV funding. And she says, poor guy lost his home. His rent is $1,050 and he gets $1,400. Um, he's applied for Section 8 housing, but hasn't gotten. His utilities run $200 a month. He gets food stamps and can't afford to eat. Talked about food stamps. He's getting debt collection notices. We'd probably enroll this guy for free. It wouldn't cost anything. We'll go over him. He needs to get cheaper rent. We'll go over it with answers, be able to help him. Sometimes, like anything, it's better for someone to contact us sooner than later. Maybe this is the kind of a case where that could be. And you don't need to be bashful by contacting us. We have thousands of clients. We've been doing this a long time. We know what to do to help people. So don't hesitate to contact. You will not feel bad. We're not going to make you feel bad. If anything, you're going to feel good. You're going to say that after we're done. If you know how many times I've talked to people and they say, "Oh, feel so relieved, Eric. I feel so much better after talking, knowing that I'm going to be okay." So I say that to you. So this person contacts. This might be my last one today. Seriously, I'm starting to get a little tired, to be honest with you. It says, my name is whatever it is. They live in Michigan. And I want to see if you could help me. Then, okay, and then we call them. And they've had recent medically related issues. Medical debt. She tried to help her kids. Trying to get a job. It fell through. She rented a car that someone stole. And says Enterprise is holding me responsible. Struggling with credit card debt, and if she pays them, she will not be able to afford groceries and her medicine. She's current on her debt. We can stop paying the debt. We don't want you to go without medicine or groceries. Remember, your Social Security is protected. It can't be taken. You're going to be fine. And helps is going to prevent the creditors from calling or bothering you anymore. You don't need to worry. So that's our message from Helps, is that if you owe debt, can't afford to pay it, your income's protected, we can protect you from the collectors harassing you. We're going to be there for you. When we're done with this today, our phones are going to be open for at least another 4 hours, no matter where you are in the United States. And we're going to be answering phones tomorrow and the next week. You can always call and talk to us. 855-435-7787. Don't worry. If you have any questions, call us, and everyone have a great day. God bless. Bye.